The case of Socorro d. Ramirez vs. Court of Appeals in Ester S. Garcia Gr. number 93833, September 28, 1995. Doctrine of the case. Republic Act No. 4200 prohibits the secret recording of private communications or spoken words without the consent of all parties, regardless of whether the person making the recording is a participant in the conversation. The law makes no distinction between recordings made by a third party and those made by one of the parties to the conversation. Hence, even a party to a private conversation who secretly records it without the consent of the other party commits a violation of RA No. 4200. The nature or subject matter of the conversation is immaterial. What the statute penalizes is the act of secretly recording a private communication using devices enumerated in the law. The terms private communication and private conversation are synonymous, both falling within the constitutional right to the privacy of communication. Where the law makes no distinction, courts should not distinguish. Facts of the case. Socorro d. Ramirez filed a civil case for damages against Ester S. Garcia, alleging that Garcia verbally abused, insulted, and humiliated her during a confrontation inside Garcia's office. To support her claim, Ramirez secretly tape-recorded the confrontation and produced a verbatim transcript of the recording as evidence. Upon learning of the recording, Garcia filed a criminal complaint against Ramirez for violation of Republic Act No. 4200, Anti-Wiretapping Act. An information was filed alleging that Ramirez, without Garcia's consent, willfully and unlawfully recorded their private conversation using a tape recorder and thereafter communicated its contents to other persons. Ramirez filed a motion to quash, arguing that RA No. 4200 applies only to recordings made by third persons, not by a party to the conversation. The information failed to allege the substance of the conversation. The law penalizes private communications, not private conversations. The trial court granted the motion to quash. On appeal, the Court of Appeals reversed, holding that the facts alleged constitute an offense under RA No. 4200. Ramirez elevated the case to the Supreme Court. Issue and ruling. Issue 1. Whether RA No. 4200 applies to secret recordings made by one of the parties to a private conversation. Yes, the law applies even to recordings made by a participant to the conversation. Section 1 of RA No. 4200 makes it unlawful for any person not authorized by all the parties to a private communication to secretly record such communication. The statute does not exclude parties to the conversation from liability. Legislative intent, as shown in congressional deliberations, confirms that unauthorized recording by any person, including a participant, is prohibited. Ramirez recorded the conversation without Garcia's consent, thereby violating the law. Issue and ruling. Issue 2. Whether the substance of the recorded conversation must be alleged in the information. No, alleging the act of secret recording is sufficient. RA No. 4200 penalizes the act of recording, not the content of the communication. The information sufficiently alleged that Ramirez secretly recorded a private conversation using a tape recorder. The failure to allege the contents of the conversation does not negate the existence of the offense. Issue and ruling. Issue 3. Whether private communication excludes private conversation under RA No. 4200. No, the terms are synonymous. The ordinary meaning of communication includes conversations, and legislative records show that the law intended to protect the privacy of conversations. The confrontation occurred privately inside an office. It constituted a private communication protected by the statute, thus falling within the scope of RA No. 4200. Thank you for listening.